Welcome to another webinar by Granite Insurance, where it's our goal to empower you guys in your operation to be even more successful, one little nugget at a time. I'm Cameron Annis, our national practice leader for our adventure and entertainment division. And we were fortunate to work with a little over 300 adventure and entertainment clients throughout the US, which really places us in a unique position to see a lot of successes that these operators have. And unfortunately, a lot of obstacles that circulate within the industry as well. These sessions are intended to address many of those obstacles that we see in the industry. A quick favor, at the end of the session, there'll be, as you exit, there'll be a little survey that pops up in your browser, and it's about future webinar sessions. You know, these ideas come from you guys, and we'd love to know what you want to hear more about to be able to help your operations be more successful. A couple of housekeeping things. At the bottom of your screen, you'll see a Q&A function field, and ask questions in that Q&A function. Leah's going to go through a lot of great things, and she's going to pause after each kind of point that she's going to make, and we're going to address some questions. So just ask those questions in that field. Be interactive. You know, the best conversations come from your ideas, your questions. We love to hear those things. So today's topic is on waivers. We know that's a hot topic. We had a little over 100 people sign up for this webinar. A lot of those people join us today, and a lot of those get the recordings afterwards and distribute it to their staff as well to, hear topics, or so that the staff can hear on the waivers. And many of us have waivers. But my question, and I'm sure Leah's question, is how many of them are actually effective? My 15-year-old daughter and I, quick story for you guys, we went hang gliding last week. It was super fun. Went up to 2,500 feet in elevation, and then they just cut us loose. And the instructor, whenever we were preparing and he was going over all the kind of ground school things, he says, "Hey, I have an emergency parachute here. The great thing for you guys is in over 4,500 tandem flights, I've never had to use it." And in my opinion, waivers are similar to that emergency parachute. So many of us have them, and we hope we never have to rely on that waiver. But my question for you guys is, if you did have to pull that ripcord and rely on that waiver, rely on that parachute, what would you find out? Would it work? Or would it basically be a piece of saran wrap and that doesn't help you at all and you go plummeting to the ground? Today, we're honored to have Leah Corrigan from Recreation Law Group with us. Leah is an avid adventure seeker and understands the adventure and entertainment businesses that we operate in. In fact, Leah was a wilderness guide herself for over 10 years. She's the founding and managing attorney from her firm and specializes in the recreation and the adventure industry. Leah's going to be awesome today. She's going to review a couple of really cool things. So with that, I'm going to turn it over to Leah. She's going to share a PowerPoint that we're going to go over and go through. Have fun, make this interactive. Leah, I'll let you take it away.
Thank you, Cam, and thanks everyone. Excited to be here. I'll just get started here and share the screen, and we'll walk through this. As I'm doing that, I think Cam's point about the ripcord and the parachute, that's a very good example. Most of you won't ever need to use something like that, but in my work, I see people using their waivers every day. Some successfully, some not. So it is something that happens and something that's worth being prepared for. Let's see here. Just give me 1 second. Cam, would you mind sharing? Because I'm having a little difficulty getting this to work. Okay, thanks. So as Cameron is pulling that up, I'll tell you a little bit about my background beyond what he said. As he mentioned, I was a wilderness river guide for about 10 years. I have many clients in the outdoor and adventure industry, across industries, from kids camps to ski areas to river companies, zipline operators, you name it. Those are the types of clients that we like to work with. What I try to do is give really practical advice and not to bog you down in a bunch of legal theory. So I want everyone to understand how this stuff works and understand it in a practical way, not in a kind of pie in the sky lawyer way. So I'll try to come at it from that perspective. So if you have questions, definitely ask those questions. This is a great time to get some of those answered. Next slide, Cam. And we can roll right through those photos of me having fun since we're all sitting in front of a computer here.
A disclaimer.
A disclaimer, that is legal stuff. So even for those of you that are clients of mine who might be on this Zoom call, we're giving you this presentation for educational purposes, and Cam and his firm were kind enough to make that available to you. However, this is information, not legal advice. Happy to give you legal advice, but you need to call me and talk to me specifically about that. Okay, next. So here's what we're going to cover. I want to talk about some key legal concepts. Again, not to bore you with this, but I think taking the legal theory out of this and making it practical really helps people understand why this stuff is important and how to apply it in their operations. So we're going to talk about just some basic key legal concepts. We're going to discuss your unique operation and why you need a waiver to cover your operation and not someone else's. We're going to discuss the concept of assumption of risk. This is something that a lot of folks don't really know about, and it's really a key legal defense that needs to be wrapped into your waiver. We're going to talk about whose signature you want on that document. We're going to discuss whether this should be a solo document or whether it can be included in other materials and some common mistakes I see there. And then talk about why it's important to use legal counsel to draft your waiver. All right, next. Okay, first, let me clear a couple things up. I hear a lot from people, oh, a waiver is not worth the paper it's written on. And in a very few states, that is arguably true. But in the vast majority of states that you all operate in, it is a very effective tool and a very effective tool to defend your cases. So what does that mean? If I am a plaintiff's attorney, an attorney that represents people who are doing the suing, so someone who gets hurt and wants to sue you, and someone comes into my office and I'm trying to figure out whether to take their case or not, one of the very first questions I'm going to ask is, did you sign a waiver? Because if the person signed a waiver, that is such an effective defense if it's good, that I may not even be interested in taking that case on. So there's a real deterrent effect. Some of you may know this, but plaintiffs' lawyers typically take cases on a contingency fee basis, which means they take a cut if they win. They'll take like 30% of the total award if they win. So if they don't win, they don't get any money. And that means they spent a year or two of their lives litigating a case to make absolutely no money on it. No one in their right mind would do that. So the presence of a waiver can actually keep you from ever being sued in the first place. So it's a super important tool. Secondly, a good waiver can mean that your case gets dismissed at a very early stage in litigation. So before you ever have to be in trial and have to have depositions taken, et cetera, a waiver can result in dismissal of the case at a pretty early stage. If you get your case dismissed at an early stage, that really limits the cost that for the insurance company to defend your case. And as Cam would tell you, I think that's going to impact your insurance premiums going forward. It also, if you're not in trial, there's going to be less media coverage. You don't want media coverage of an incident that happens in your business. That can be really incredibly damaging. And also the time and emotional cost and business interruption of a lawsuit. I can tell you, my clients that are in lawsuits right now, worst couple of years of their lives, hands down. So if you can avoid that by having a good waiver, that's worth your time. Okay, next.
I'll echo exactly what Leah's saying there. You know, we see our fair share of lawsuits, and it is so often whenever we present, opposing counsel with the waiver or, a copy of their surveillance, something of that effect that they didn't realize was, there to begin with, they say, oh, and then they automatically dismiss themselves from the case because, like Leah said, they don't want to spend an hour or, a year of their time working for free. So, Leah's spot on there.
Okay, key legal concepts. So don't fade out here. I know this looks like a lot, but I think this is super important to understand and actually really interesting. So let's talk about a couple of things. We're going to start with negligence. What's negligence? That's what you get sued for as an adventure operator if you have a death or an injury. Negligence is failure to exercise ordinary care, which results in injury or death. So negligence is you doing something really wrong, like that we would all agree is probably not okay. Inherent risk, on the other hand, is a risk that's present in an activity that you cannot effectively eliminate, alter, or control. So I think about your operations. I bet you can think of something that, okay, this is inherent risk, but this would be negligence. So in rafting, for example, an inherent risk of an operation like that is drowning, right? It's always possible to drown if you're going on a whitewater raft trip. That risk cannot be eliminated. But what if you drown because you weren't fitted with a life jacket, a personal flotation device? If you weren't fitted with a PFD, most of you that are rafting operators here would say, yeah, if you don't have someone in a PFD and they drown, that's probably negligence. Those are two different concepts. So within your waiver, you should have those two concepts within that waiver. And that I think is often missing from waivers. So a waiver or release is, I release or waive my right to sue you, even if you are negligent. So if you're the operator that didn't put a PFD on and I signed a waiver, then arguably I've waived my right to sue you, even though we all agree that you did something really bad and stupid. So that's waiver. Assumption of risk is a separate legal defense that should be included in your waiver. That is, I contractually assume the inherent risks of your operation. So the reason why these are important and different concepts is they're both separate defenses in a lawsuit. They're within the same document, but they're separate defenses. So if that waiver defense fails for some reason, or is not enforceable under your state's law, for those of you operating in Oregon, there was a bad case out of the Supreme Court that really called waivers into question. But that assumption of risk defense is still a good defense. So having that in your waiver and both of those concepts in there is super, super important. And it's important for you to understand the difference. Next slide, Cam.
Well, yeah, what's the difference between negligence and gross negligence? And does that have any play on waivers?
Yeah, great question, Cam. So gross negligence is conduct that is so outside of ordinary care, so far outside of ordinary care that it's almost intentional. So an example of gross negligence, again, to stay within the rafting concept, is you run a class 4 rapid at high water. Everyone in the industry considers that unrunnable, and they require everyone to walk around that rapid. But you have a guy who decides, what the heck, I want to give it a go. You've got 4 people in your boat, 2 60-year-olds, 2 kids, run the rapid. The boat obviously flips because it's unrunnable. That's gross negligence. And that would be an example of, that's so far out of this industry standards that no one would think that was okay. Does that make sense, Cam?
Yes, thank you for that.
You're welcome. Okay, so now we're jumping into the 5 most common mistakes. We'll start here with mistake number 1. In my litigation practice, so we work on both sides of the fence here. We prepare people for getting sued by drafting really good waivers, but I also defend clients who are sued who may have whatever waiver that they had from wherever. So mistake number 1, and I think everybody understands this instinctively, but people are still tempted to do it. Don't copy a random waiver. That is almost never going to work out in your favor should you get sued. Some common problems with that would be, let's say you have a buddy who runs a zipline operation in a different state, and they have what looks like a pretty good waiver, and they say, hey man, you can use this, save you a couple $1,000 of attorney fees, and you use that waiver. Well, I draft waivers in all 50 states for clients as a consultant. Those look really different state to state, really different, because the state laws change. Supreme Court cases come out, like in Oregon. And if you don't adjust the language of that waiver to address those state law changes, it's not going to be enforceable. So the chances of you using a waiver that was drafted for someone else in another state and that working out for you, not good. The other common mistake I see is that you don't have the proper released parties listed. So if you're an LLC and you have both employees and contractors and partners, and maybe you have investors, and maybe you operate on private land, all of those parties need to be really carefully and specifically listed as released parties. That thought exercise is something attorneys spend a lot of time making sure that you have the correct release parties and really thinking through making sure everybody's covered. If you copy some random waiver, different business model may not have those proper release parties. Also, this concept of wrong risks, if the inherent risks of your operation might be very different than the inherent risks of even a similar operation. But certainly different than a totally different operation. So having wrong risk is another mistake I see, stuff that just doesn't make sense in the context of what you do. The other thing is, lawyers have been drafting waivers for 75, 100 years. The legal theories and standards have changed. So what I often see too with using someone's waiver, maybe the person you bought the business from, for example, is you're using language that's outdated, hasn't been updated to comport with the current legal standards. And all of those things can create a problem where instead of this waiver being a deterrent for a plaintiff's lawyer to take a case, or entitling you to early dismissal with much lower cost of defense, you've got this piece of paper, but it's not really doing much for you. And you end up going all the way through trial anyway. If you end up in trial, your waiver hasn't done a good job for you in most states. So you want to avoid that outcome. I'm going to pause there. Cam, do you have any questions, or does anyone else have a question on this first point?
Yes, actually we have one that just popped in, and go ahead and insert any questions you have in the Q&A function in the bottom. This is a great question from Katie. Is how often would you recommend reviewing and updating the language in your waiver?
Yeah, Katie, great question. I recommend for my clients, anyone who's a client of mine, I review all waivers once a year. Because like I said, state laws can change, new things come up in cases that I like to incorporate into my clients' waivers. However, I think generally speaking, if you did it once every 2 years, that's probably okay. That's a reasonable period of time.
That's a great question. Just out of curiosity, and Leah, I'm not going to hold you to this, but like, what is just to put this in perspective, like creating a new waiver, what's a range of cost that it would take to do that, so I can pair that with the consequences of not doing that?
Yeah, great question. So I can speak for myself and other lawyers that work in this very specific space of outdoor recreation, because those waivers look different than a waiver for a gym, for example. For the attorneys that I would refer clients to, I'd say the range is anywhere from $3,500 to $7,500 investment. Most lawyers do that on a flat fee basis. You can have a lawyer who doesn't have that expertise do it, but their understanding of how you list inherent risks and assumption of risks is going to be a little bit less. So I'd say a really qualified attorney, that's the range. You can get a decent waiver out of just a good local lawyer for less. I would say, $1,500 to $3,000 is about the range for a local lawyer who doesn't have specific expertise.
Thanks for that. And I guess, my point is, and this is what we tell anybody, especially startup operations, they're like, hey, we found this other waiver, change the names. What do you think about it? Is hire a professional. None of you guys would, for example, zipline operator, how many of us frown on homemade zip lines installed in the backyard because it's not done by a professional. $5,000 investment is going to save you from a lawsuit significantly. For example, if that waiver doesn't work, and let's say it's $100,000 claim, who knows, your premium is probably going to go up $20,000, $25,000 for the next several years, where $5,000 investment would have looked like a no-brainer at that point in time.
Yeah. And to that point, in terms of just real world consequences, let's say you have the worst case scenario and you have a fatality. Everyone thinks, so that's never going to happen to me. I have 5 clients this year that has happened to after 20, 30 years of operating with no problem. It happens. If you have a fatality, there's a good chance, because the insurance market has narrowed, that you could get dropped. That's not out of the realm of possibility. And there's also a decent chance that if someone pays out $1 million on your claim, that's going to have huge consequence for your premiums down the road. I have a client whose rates went from $40,000 a year premium to $370,000. That's just one example. That's, for many people who run a small business, that would be a business ending event. And having a good waiver can keep the insurance company from thinking, we've got to pay out on this claim. There's no good defenses to it.
That's great. That's great. Another question, and before I get to that question, I just want to let everybody know that Leah and I have no business relationship. I don't get paid for clients to go to Leah or anything like that. I just recognize that she does a fantastic job, and we appreciate her expertise specific to this industry. The next question is, if you have locations in multiple states, can you use the same waiver with specific state language added on? I would assume maybe they're thinking like, hey, by the way, Delaware law says this at the end of the document. Or do you need a specific waiver for each state that you operate in?
Yeah, another great question. You have a smart audience here, Cam. So I'll try to make this a short answer. One solution, if you're operating in multiple states, is to have what's called a forum selection clause in your waiver. And that would say, for example, I'm here in the shadow of the Teton Mountain Range in Idaho. If I draft an Idaho waiver, or I have a client who's in Idaho who operates in Colorado and Wyoming, I would put in there in the waiver that Idaho law applies, and that if you sue, you have to sue in the state of Idaho. So that effectively removes the application of multiple states' laws. Now, the complication there, and the reason that this takes a professional to do, is some states don't honor forum selection clauses. So you have to understand that and draft around that possibility. So there may be the simple solution of a forum selection clause, but you may need someone who can draft and incorporate different states' language. Worst case scenario is you have to use a different waiver in different states. But that's not a strategy I employ very frequently unless there's no other choice.
Great answer. I'm going to go ahead and go on to mistake number 2.
So this is solution. Yeah.
Oh, sorry. You want me to go back, Leah?
Yep. So again, don't use someone else's waiver. This investment is foundational to the protection of your business. Make sure that what you're doing is specific to your work. Okay. Mistake number 2. And we talked about this a little bit in the key concepts. You don't want to rely only on liability waiver or release language. So remember, backing up to key concepts, those 2 different defenses. Assumption of risk is I contractually assume the inherent risks of the activity. And then waiver is I waive my right to sue you even if you are negligent. So a well-drafted waiver will contain language that addresses both of those points. And the best way to draft that assumption of risk language is actually to list the inherent risks of the activity specifically, and to ask the participant to contractually assume those risks. Here's how this works when you're in court or in a deposition talking about a waiver. People often will say, if they get hurt in the context of a recreational activity, or if someone dies, they will say, I didn't know, I wasn't warned, I didn't understand, right? So can someone contractually assume a risk that they weren't really informed of, or they didn't really understand? Arguably not. So what we do in terms of drafting to solve that problem is actually list the inherent risks in detail. So for example, if you're running a horseback riding operation, we would include horses spooking as a result of encountering wildlife, slipping saddle, things like that. And you could apply that to your activity. You can think of, these are risks that I know are inherent that I need to tell people about. If you tell them about those risks and then there's good language where they're contractually agreeing to those risks, it's very difficult for them to say, I didn't know, I didn't understand, no one told me, because it's right there that they not only read all those risks, but they signed off that they understood them and they assumed them. If you're thinking about sitting on a jury and hearing about a case where someone was hurt and the attorney is arguing this was inherent risk, they assumed the risk. And we can put up on a big screen as Exhibit A, the waiver that this person signed that specifically lists those risks and contractual assumption of those risks. You can imagine saying, well, these guys obviously understood it. It's right there in black and white. You signed off on it. That can be a very powerful defense in these claims. And again, operate as a deterrent effect for plaintiffs' attorneys. Cam, questions on that or anyone else?
Yes, we actually have 3 great questions in here. Actually, these are awesome questions. The first one, if our zipline or operation traverses 3 separate properties owned by different entities or LLCs, should each of these companies be listed in the hold harmless section?
In my practice, yes, I would list each of them explicitly.
The next one, Leah, is if you have international operations, this is cool, but representation in the US, like a corporate office, how should you accommodate the waiver to make sure we're covered both in our local markets, but also, and meaning international, but also in the US where we have offices and run the risk of litigation?
That's a great question. That answer would be so long and so detailed that I don't think it's a good one to give here, but there are ways to use the forum selection tools and to put your corporate offices and operations overseas within the assumption of risk section that can address that for international operators. But the forum selection clause is a key tool.
This is my uneducated viewpoint, Leah, but I would imagine if you have operations internationally, you would probably want the jurisdiction to be internationally just because it's not near as litigious as the US. Is that correct?
It depends on the jurisdiction, but generally speaking, yes. However, there are places like New Zealand and Australia that really tightly regulate recreation operators and have jurisdiction to shut down your operations over there if you get sued. So it's really going to depend on the country.
Good. A couple of more questions. We get many visitors where English is not their first language. Are we liable if something happens and the participants claims they didn't understand what they were signing? Are businesses required to have waivers in multiple languages?
Yeah, another great question. So this again will depend on your jurisdiction. So for example, if you are in the Ninth Circuit, which is the federal court system that is the Western US, if you're in California, there are a couple of other states that have states, Supreme Courts that have addressed this specifically, then I would have the waiver available in multiple languages, particularly Spanish. That's the big one. In other states, that's not yet necessary. So in the Intermountain West, there's less case law suggesting that you need to have it in multiple languages because there's the theory that this is an English-speaking country. You need to be able to read and speak English. And if you don't understand a document, you need to ask for it to be translated. So there, again, that illustrates why this is very different state by state. What I would say, generally speaking, forecasting is that it's probably smart to have your waiver be able to be translated into multiple languages, especially if you're in an urban area where this is a frequent problem. You're just eliminating the argument, which is good. And with the rise of, AI, translations of waivers are actually pretty good and pretty inexpensive. So to the extent you can incorporate that into an iPad or your operations, I think that's smart.
That's again, oh, sorry, Lee,
state by state. No, sorry, I was just going to say state by state. You may not need to do that, but eventually I think that's where it will be headed.
I would agree with that. I mean, it's such an easy argument if it's a Spanish speaking person and it's only an English waiver. It's an easy out. What I see a lot of lawsuits is it's a game of poker, and that's a chip in their stack. If they have that argument in their stack, which makes your case a little bit weaker. That really leads into another question that was asked, talking about the translation, AI, and digital waivers. Makes it very easy to say, hey, what language do you want your waiver in? Physically signed waivers makes that a little bit more difficult. They may not even know that you have another copy of a waiver in a different language. What's your thoughts on digital signed waivers versus, paper waivers?
I think that the way that the market has responded to the need for digital waivers, there's some really good, really slick, really cheap options for digital waivers. The devil is in the details, though. So again, I have no affiliation with either of these companies, but I think they've done a good job making this legally compliant. Smart Waiver, Waiver Sign, Flybook, just as 3 examples off the top of my head. Those digitally signed waivers can tie the signature to a time, date, and IP address. They have a box that you have to check that says, I certify that I am the person who's signing below. And there are ways to specifically tie the waiver to the person. So I think digital waivers are great because they can be kept for a long time. You're not moving boxes around. You can't lose them. You can't accidentally use the wrong copy because you have front office staff that didn't understand the difference between 2 different waivers. There's a lot of human error that can be eliminated by a digital waiver system. So I like them when they are set up properly. I don't like to have people just use, a random digital signature program like Adobe Fill and Sign. Like that doesn't have the proper ties to IP addresses, backup copies, email copies, etc. But generally speaking, I do like those digital waiver programs.
It's great. And we actually have multiple people asking somewhat of the same similar question. And this will be the last question that we go over before we kind of go to mistake number 3 is, all right, we have inherent risks and we're listing those inherent risks. What happens if we miss one? Like what happens if we don't list something that actually happens? Does that make our argument weaker saying that, hey, we listed out these things, but we forgot this one and it happened? Can you talk about that, Leah?
Yeah, that's again, great question. So when we draft waivers, we will include language, catch-all language that says, we've made our attempt to list all the inherent risks. You have the right and obligation to do your own research as well. You assume all risks, whether listed here or not, whether inherent or not. So there's some catch-all language that we can draft to address that question. But what I will say is, I spend a lot of time with clients. We charge a flat fee for a waiver, and I spend sometimes hours doing research, talking with clients, doing multiple drafts, having clients have their office staff, other people review the list of inherent risks to make sure that we really are capturing all of them. And in the last 5 years or so, really in the course of my career, I haven't had someone raise an argument that was an inherent risk that I didn't capture. So I think you can capture most of them, but we do include that catch-all language to draft around it just in case.
That's great. Awesome questions, guys. Keep them coming. I'll hold kind of the questions that are left and the to-come questions that you guys are going to ask until after mistake number 3.
All right. Okay. This topic is unpopular and kind of a bummer for people because it's mostly news that makes life difficult. So the third mistake that I see, and this is a catastrophic mistake, if you make this mistake, your waiver isn't worth the paper it's signed on, is letting the wrong party sign the waiver. So let's take my family, for example. My husband and I, we have 2 boys, 8 and 10 years old. If I go to a zipline tour and I sign a waiver for myself, I sign a waiver for my older son, I sign a waiver for my younger son, then that's good, because now that zip line operator has a parental signature on a waiver. What if my kid was 17 and he just signed the waiver himself? What's the problem with that? The problem with that is that under the law in the US, and this is uniform across all 50 states, you don't have the legal ability to sign a contract, which is what a waiver is, until you are 18 years old. So if you have a minor's signature on a contract, that is not enforceable. Only the parents can sign that waiver. Now, let's change the example and say, what if my mom took the kids to the zip line, which she would never do because she's terrified of heights. But let's just say that happened. Can grandma sign the waiver? Is grandma the parent or legal guardian under the law in your state? If she's not, if she's just standard grandma, no, she doesn't. She can't sign away my child's right to sue for injury. That right to sue belongs to me as the parent, and only me. I get to make those decisions, or my husband. So grandma, parents, a friend's parents, if two families are going together, a teacher in a school group, a Boy Scout leader, none of those people can sign a waiver on behalf of a minor. If they do that, you really just don't have a waiver. It has to be the parent. That's super important. Also, similarly, I can't sign for my husband. His right to sue is his right to sue. I don't own that. He does. So I can't sign that right away. I can't sign for a friend. I can't sign for 4 people. It has to be one waiver per person. And that is true, again, across all states. That's a really common error. Now, when I tell people this, they say, well, what about this situation? And what about that situation? And that's impossible to deal with. And I agree. Some of this is really hard, like with school groups, et cetera. But having electronic waiver programs where you can send the waivers out ahead of time to multiple email addresses makes this easier. But it really is, the point really is, if you have the wrong party sign the waiver, I wouldn't even bother. It's not actually going to do anything for you in court. So with that bad news, does anyone have questions about how to deal with it?
They're flooding in. I'm making my way. I'll take kind of, and I knew this one was going to come up, and you briefly touched on this, Leah. All right, summer camp. Parent signs, a summer camp agreement or educational field trip, whatever it may be, is like, hey, the chaperone is responsible for my kid. Whatever, this is my 2 weeks, so I don't have my kid. Do whatever you want to with them. What do you do then? Does that chaperone have are they the legal guardian for that kid over those 2 weeks? What's the rules around that, and how do you administer that?
Yeah, great question. So unless the chaperone is given a legally binding power of attorney by the parent, which I can guarantee you is not happening in 98% of cases, unless there's a power of attorney, which is a legal document signed with a notary saying, I give you my rights to as a parent, I hand those over to you as chaperone to make all decisions for the health and welfare of my child, to sign any documents, etc. A power of attorney can be effective. Other than that, though, a permission slip saying the chaperone is in charge of my kid is not going to give them the legal authority to sign a waiver.
That's good. Which, again, to your point, like, that is the bummer. That is this is what makes this, a little bit difficult from an operation perspective. Following up on that, and 2 or 3 questions kind of point back to this same question I'm about to ask, Leah, is, what's the responsibility of the operator to verify that, hey, you are the legal guardian, or you are the person that you're actually printing, the name on the waiver. You are that actual person. What's the, due diligence or the care responsible for the operator?
Yeah. I mean, the due diligence or the responsibility of the operator depends on your risk tolerance, right? So if I walk in and I say, yeah, I'm this kid's mom, what's the least risky way to proceed? Ask me for identification, match it to a kid's birth certificate, and then let me participate. So that would eliminate the risk, right? But what in practicality are you going to do that? No, most people are not going to do that. That's not compatible with the way that you run a business. So you're just tolerating some level of risk that someone might lie to you, and that's going to be the waiver that you have to use. So that's again just a risk tolerance question, because you can't eliminate it. That's really an inherent risk of operating your business. But I would say, again, it's up to you. Like, how far do you want to take it? If you want to be 100% safe, you got to match the idea of the mom to the kid.
And again, I think Leah would agree with this. All of us on this call, including Leah and myself, we are in the business of risk. Can you operate a 100% risk-free operation? No, you'll never be able to do that. But to Leah's point, it's how much risk are you comfortable accepting versus how much can you push out to other people's or eliminate that risk. Of course, the more you can push out or eliminate, the better. But there are some things you just have to accept the risk. For example, another question came in is like, hey, are you saying that, we just should stop doing student groups and school groups? It's basically impossible to get, number one, power of attorney, or even get the parents' emails to send in the waivers ahead of time. And Leah, I don't know if, correct me if you disagree with this, but it's like, yes, you can do everything you can, but sometimes you can't do everything or prevent that from happening. Best case scenario would be, yes, you should be sending that waiver electronically to the parents so they could sign. But I guess a question for you, Leah, is do you have clients or have seen clients that at some point are like, we're just going to accept the camp counselor signature and roll from there?
Yeah, great question. I think this was a much more difficult problem before electronic waiver programs, because now it is possible, if you're contracting with a student group, to say, send this out to the parents ahead of time and make sure these are returned before you show up on that day. And I think that's the best practice. When I have explained this to clients, most people are willing to put in the work to set up an electronic program that works for them, because you've built a business, put all this time, money, effort, investment into it, and trying to eliminate that risk is worth the investment of time or in electronic programs to eliminate that. Where you can't eliminate 100% of the risk, that's what insurance is for, right? Is where you can't eliminate or you haven't been able to mitigate that risk, and it just is what it is. That is why you buy insurance, is for those types of outcomes.
And of course, from our side of things, the more risk, the more premium. So, if you're willing and saying, hey, we don't want to eliminate risk, okay, that's fine. It's just, that translates to more premium.
Yeah. Let me make one more point too, which is, again, not good news, but can change the risk calculus for some folks. So in many states in the US, waivers, and this is different from assumption of risk, waivers, I waive my right to sue you even if you're negligent, are not enforceable for children anyway, right? So there are courts that say a parent can't waive their kid's right to sue, period. Even if the right person signs it, that's not a legal defense that we're going to accept. That's true in multiple states across the country. So if you happen to be in one of those states, then whether you need to get a parent signature takes on less importance, right? Because that's not a defense that's going to be available to you anyway. Assumption of risk is a good defense in almost every state. So it's still worth having a assumption of risk or waiver form, even if the waiver portion of that isn't going to be enforced. But that, for those of you that do deal with a lot of kids, it's worth really understanding the law in your state about the enforceability of waivers and assumption of risk for children, because that may mitigate in favor of you not making a lot of effort to make sure every single parent signature is covered for a school group.
These are great questions, and great points. Keep the questions rolling in, guys. I will tackle this one, and then we'll move on to mistake number 4, just so we make sure we have enough time to get through all the mistakes. But the last question before we move on that I have, Leah, is, does asking a signer who is not the parent to attest that they are the legal guardian? So maybe, for example, a little box saying, hey, I'm not the parent, but I'm the legal guardian. Check. Does that provide some measure of protection for the operation?
I think it provides a practical measure of protection because some people aren't going to be willing to lie and check that box if they're not the parent or legal guardian. However, let's say that I let my kid go to a sleepover and the parent decides to go take them off to a bounce house. I didn't give my permission. I knew nothing about that. And that person also checks the box that says I'm a parent or legal guardian. Am I, as the actual parent, going to be contractually stuck with the fact that someone lied to take my kid somewhere? No, probably not. So I don't think it provides you a lot of legal protection. It just, again, provides some practical protection that you're hoping that most people aren't going to check the box if it's not true.
Great. All right. Mistake number 4.
Okay. This is a really good one to pay attention to if you're running a summer camp or a multi-day operation where you have multiple registration documents. So the fourth mistake that we see a lot and that we definitely don't do when we're drafting is to bury the waiver within other documents or include a bunch of extraneous stuff in your waiver. So burying the waiver within other documents, a good example would be you're running a summer camp, you have 5-page registration form, emergency contacts, dietary preferences, whether the kid likes soft pillow or hard pillow, etc. Medical forms saying what kind of medical conditions, medication the kid has, cancellation policies, pickup policies, electronics policies, and then somewhere in that long document that you send to register is a waiver. The argument that people have made successfully in court is that I didn't really realize what I was signing because this was buried within a whole bunch of other documents. And courts have accepted that argument and said, no, it needs to be a very clear, unambiguous, everyone understands it's a waiver and that they're signing that document. Mm-hmm. So you don't want to bury it within other documents, including extraneous stuff would be, putting a cancellation policy in your waiver, adding just all sorts of whatevers that may be useful for running your business, but aren't directly relevant to assumption of risk and informing and warning and waiving for that participant. So you only want to include directly relevant provisions in your waiver. I'm pretty militant about this. The only thing that I will include is one sentence of a photo release. That's the only thing that I've agreed to include. Anything else, and that's at the very end after all of the most important provisions. Anything else, I don't include that. So you want this document to be a standalone document, well labeled, pretty decent sized font, that clearly tells people it's a waiver, and then you want the signature to be attached to that document, not a signature for all the documents, but a signature attached to that specific document. What lawyers want to be able to do is to take that document, print it out, and hand it to the judge as Exhibit A, saying, here's what this person signed. And it's very clear that they signed it, it's clear that they understood it, etc. That's
great. A couple of comments and questions, Leah. A comment a couple of people have made is, this isn't a comment, it's just, or this isn't a question, just a comment, but they've made the comment that this is such an awesome workshop. Like this would be amazing to have at America Outdoors or ACCT or, Arrival, some of the specific associations for the industry. So just something to put in the back of your mind. And thanks for doing this for us or in partnership with us. The question I have kind of about burying things is roster waivers. How do you feel about roster waivers? And by roster waivers, I mean, all right, we've got the waiver on one side, and then we flip the piece of paper over, and then it's an Excel document printed off on the back. It's like, hey, you sign it, you sign it, you sign it, and it's just a list of people on the back. How do you feel about those? What's the defensibility of those around roster waivers?
I prefer that you don't use roster waivers. Again, I prefer one piece of paper per person. That's what I'd call the gold standard. However, if you have a roster waiver where it shows the waiver and then it shows the signature, or a checkbox that someone actually signed it, I think that could be okay, as long as, and this is the big if, as long as there's no argument that they didn't sign it. And you can be absolutely certain that a plaintiff's lawyer with a roster waiver is going to try to find a way to say, my client didn't sign that. I don't know where you got that information. So I think, again, gold standard is 1 page per person. But if you use a roster waiver, just make sure that you can tie that signature to the first page of that document.
Thanks for that, Leah. We work with several insurance companies who will not even allow roster waivers. Just from it creates so many loopholes, as Leah has mentioned. Did they actually turn the piece of paper over and get the opportunity to review before they signed? I can tell you the last roster waiver I signed, I didn't turn it over. I just signed it and went on my little snorkeling tour and carried her on, and here I am today, still alive. That's great. But we'll move on to keep flowing with the questions and answers. Thank you for the questions. Thank you for those. And we'll go on to mistake number 5.
Okay, well, this was 0.5, but Cam already made it 0.1, so we won't belabor it too much, and we can jump to any other questions that people have. But to Cam's point that he first made, if I tried to set up a zip line in my backyard or tried to start a mountain bike operation without the proper certifications, people in the industry would look at that and say, you don't know what you're doing. You shouldn't be undertaking that professional task. I think that is also true with liability waivers. And that's probably become apparent to you over the course of what we've talked about here. There is really specific research and careful thought and training and experience that goes into creating a waiver that will actually do the job it's intended to do. And are there non-lawyers who can do this work? Maybe. I mean, you may be able to cobble together something that's okay and that might work. But the question you have to ask yourself is this an investment that I need to make, or is this something that isn't a place that I need to spend money? And that's true in your operations, whether it's vehicles or new equipment or whatever. You're constantly doing that calculus of where do I need to spend money? Where can I not spend money? And I think that's an appropriate calculus. There are actually some legal concepts and documents that I think, and we do educational programs for our clients, as Cam does. There are some legal documents and concepts that I think you don't actually have to have a lawyer for. I'm not a lawyer that believes you need a lawyer to do every legal thing. Some of this is not rocket science. However, a waiver does not fall into that category. That's a very specialized document. And just speaking for myself, I've been practicing law for 15 years. I was a guide for 10 years before that. I use all of those years of experience to draft documents that actually work for my clients. And I use pieces and parts of my life that, you can't get if you don't go to law school and actually practice law. So I think that's a do lean on your legal counsel. It's a foundational investment in your business.
That's great.
Any other questions?
This is the point. There's Leah's contact information and everything. This is the point. Throw any questions you guys have, whether on topic, off topic. This is a point where you have Leah's attention and she's not on the clock charging you. So ask away on the questions. Good. I think we hit all of the questions as we went through the presentation, Leah. I want to thank you. We took up right at the full hour, which is great, and did not go over, which was typically my concern. This was, I think, probably one of our best sessions, specifically because I was not the one speaking, but we had an awesome presenter in Leah and talking. Thank you guys for joining the session. One question just flowed in. If the client does not fill out their full address, full name, first and last, birthday, etc., is the company liable, or is that on the client because they lied on a legal document? For example, if they have to be 18 years old and they did not fill out their birthday, whose responsibility is that? Is the company liable, or is that back on the participant?
Yeah, that's a great question. So there can be ramifications for the participant. There may be a criminal statute that applies to lying on a legal document, but the unfortunate answer is that it's really going to fall back on you no matter what, because the main point is, if the waiver doesn't work because it's the wrong signature, wrong person, whatever, that becomes your problem, whether it should be or not, is the unfortunate truth. So there may be some ramifications for participants, and some of that you can draft into the waiver itself. But ultimately, it's in your best interest to do your absolute best to make sure you've got the right person, right signature.
That's great. With digital waivers, is a picture of the person signing the waiver helpful?
Very, yeah. That's great. I haven't had to use that technology yet, but I think to the extent that someone said it wasn't me, yeah, if you've got a picture of them, they can't say that anymore. It's just like surveillance video. So yeah, I think that's super helpful.
That's great. When you have multiple activities, Leah, at one location, for example, kayaking, ziplining, axe throwing, do you need multiple agreements for each activity, or is one encompassing agreement okay to have?
Generally speaking, we try in my practice to use one agreement and just list the inherent risks of the different activities within that inherent risk section. There may be some activities that are so different that you can't really make the inherent risks make any sense. And in that case, you may use two, but I would say that's a pretty rare case for us. We try to use one document.
For example, if you have, I'm just trying to think, I'll say hang gliding, I did last week. If you got hang gliding and then you've got snorkeling, you probably have, completely different assumption of risks with those two activities.
Yeah, absolutely. And if it's in one location, that's one thing. But if you're a company who's doing different things in different places, then that may mitigate in favor of having multiple waivers.
That's great. Well, that's the end of our questions list. Thanks, guys, for joining. This is recorded and will be sent out to everybody that's registered. Feel free to pass it along to your management team, staff, friends in the industry, whatever it may be, if it's helpful to you. We'll see you guys next time. We'll probably be doing another webinar probably in November or December at the end of the season, and submit the answer to that survey question so we can determine what that is. Thank you, Leah, for hopping on today, and everybody have a great rest of your week.
Okay. Thanks, Cam. Thanks, everyone. Have a good week.